Well, under the copyright law, basically says an artist, when you fix your expression in a tangible medium, there's a copyright created that you own. So when you sing it onto a tape recorder or you write the words down onto a piece of paper, there is now a copyright that accrues to you. As an evidentiary matter, there's a registration process. So again, I always tell clients, look, it's an insurance policy. For a $45 filing fee, and on a Form SR, particularly with producers, I'll tell them, look, you can take 10 or 20 tracks and put them on that Form SR, you know, for $45. Not only is it proof of the validity of your claim and that your copyright ownership, but if you win in the lawsuit, you know, you can get your legal fees awarded, which you can't get if you don't file the copyright form. So I think the restriction is you have to file it within 30 days or 90 days of publication or prior to the infringement. So the problem is, and this comes up all too often, the producer created a track or the artist wrote a track with someone and they own the copyright, but they never registered the copyright. Now it's been used somewhere, it's been infringed, it's been published. So we say, fine, go file the form. I'll write a demand letter, but if that doesn't work out, we're going to have to sue. But because we filed the form after the infringement occurred, we won't get legal fees on top of whatever we win. And the advantage to having that is it's huge leverage because it means the other side is going to have to pay your legal fees in addition to whatever they owe you. And you know, that can get ugly real fast. Now, again, it works both ways, but assuming you have a legitimate claim, you know, it's a shame, let's put it that way, that you didn't spend the $45 to register your copyright. So basically, you own the copyright when you fix it in a tangible medium, but for $45 you can register the copyright and basically not only have a stronger position, you know, for yourself, but have the right to get legal fees awarded if you prevail. And like I said, that can be almost as much as you want in damages if it's a long drawn-out case. For copyrights, it's the Library of Congress. Again, it could be Form SR if it's a sound recording, Form PA for individual songs, and then for visual arts, it's VA. Each form has something different. You can go online, it's www.loc, which stands for Library of Congress, loc.gov, and go to copyright and go to forms, and all the forms in there, and you can print out the forms, and it explains what the forms are, and then you fill them out. And in most cases, you send it in with one copy of the work, or if it's already been published, 2 copies of the work. And it's basically a name and address form. You know, your name, when the work was created, a couple of basic miscellaneous questions, who's claiming it, which again, if it's you as a writer, it's you. It's a very simple form to fill out. In most cases, if I have to walk a client through it once, that's all that's necessary, and after that, they can do it themselves.